Losing a loved one is one of life's most profoundly difficult experiences. In the midst of your deep grief, the last thing you want to navigate is a confusing, unfamiliar legal process. Yet, this is exactly when you might hear the term probate. Understanding what probate is and how an attorney can guide you through it can alleviate tremendous stress.
Before we begin, this video provides general guidance and is not a substitute for legal advice. Always consult a qualified professional tailored to your family's unique situation. When a loved one passes away, you might hear the term probate being used, but what exactly is it? Simply put, probate is the formal legal process of administering a deceased person's estate. It is overseen by a local probate court to ensure that everything is handled correctly, transparently, and in accordance with the law. The probate process generally involves 4 core steps. First is validating the will. If the deceased left a will, the court must confirm its legal validity before any further action is taken. The second step is identifying and inventorying all of the deceased assets, from real estate to bank accounts. Once assets are tallied, the third step is paying off any outstanding debts and taxes owed by the estate. The fourth and final step is distributing the remaining assets to the rightful heirs. If your loved one died with a valid will, they died testate, and their wishes dictate the distribution. But if they died intestate, meaning without a will, state laws will determine who inherits the assets. Navigating the aftermath of a loved one's passing is never easy, especially when legal complexities arise. Enter the probate attorney, a specialized lawyer expertly trained in estate and probate law. They act as your legal navigator, guiding executors and administrators step by step through an often overwhelming process. Their responsibilities are vast and crucial. First and foremost, they advise you on your fiduciary duties, ensuring every action complies with state laws. They handle the heavy lifting of preparing and filing intricate court documents, and, if necessary, they will confidently represent the estate in probate court proceedings. But their job extends beyond just paperwork. When emotions run high, a probate attorney acts as an objective mediator, managing disputes among beneficiaries or contesting creditors. They also shoulder the complicated burden of assisting with estate and income tax preparation, ensuring no deadlines or critical filings are missed. Furthermore, they collaborate with licensed appraisers to accurately value estate assets, ranging from residential real estate to valuable family heirlooms. Finally, they step in to negotiate directly with creditors, working diligently to settle outstanding debts fairly and efficiently. Ultimately, a probate attorney provides invaluable peace of mind, protecting you from personal liability while securing the legacy of the estate.
So when is a probate attorney actually necessary? While not always legally mandated, their expertise becomes crucial in several situations. Let's start with complex estates. If the deceased owns significant assets like multiple properties, extensive investment portfolios, or valuable collections, a probate attorney helps untangle the web of ownership and valuation, ensuring everything is properly accounted for and transferred.
Another major trigger is family conflict. When heirs disagree over the will's terms, a probate attorney acts as an objective mediator, preventing bitter legal battles. They are equally essential in cases of intestacy, which means the person died without a will. Navigating state-specific intestate succession laws requires professional guidance to determine rightful heirs and distribute assets. Significant debt is another concern. If the estate faces substantial creditor claims, an attorney can negotiate settlements and ensure debts are prioritized legally. Furthermore, navigating complex federal or state estate tax issues is definitely not a do-it-yourself project. Finally, if you are acting as an executor, an attorney shields you from personal liability while you fulfill your duties. There are also highly specific scenarios where an attorney's skills are invaluable. For instance, if the deceased owned real estate in multiple states, you must navigate ancillary probate in each jurisdiction. If they owned a business, an attorney manages the valuation and smooth transfer of ownership. They are vital for defending the estate during will contests, and they have the investigative resources to successfully locate missing heirs. While probate laws vary by state, The general journey follows 7 distinct steps. It begins with filing a petition in probate court to open the estate. Next, formal notices are sent to heirs and known creditors. The court then officially appoints an executor or administrator to manage the process. Step 4 involves a comprehensive inventory and appraisal of all estate assets. Once valued, the estate must pay off any legitimate debts and taxes. Only then can we reach Step 6, the distribution of remaining assets to the rightful beneficiaries. Finally, the executor submits a final accounting, formally closing the estate.
So, how long does this all take? Unfortunately, there is no single answer. The timeline for probate can vary significantly, ranging anywhere from a few months for a simple, uncontested estate to well over a year or even several years if the estate is complex, involves business assets, or faces family disputes. Beyond time, probate also involves various financial considerations. You will need to account for court filing fees, which vary by jurisdiction. There are also executor or administrator fees, compensating the person managing the estate, professional appraisal fees to determine the value of real estate or personal property, and sometimes bonding fees, which act as an insurance policy protecting the estate from mismanagement. The most significant cost is often the probate attorney fee. Depending on your state, this might be billed hourly, as a flat fee, or as a percentage based on the total value of the estate. Because these expenses add up, it is crucial to discuss fee arrangements up front with your attorney before signing any agreements. Choosing the right probate attorney is a crucial step during an emotional time. Look for someone with extensive experience, specifically in probate law. If the estate has complex assets, like business interests, ensure their expertise aligns with those unique challenges. Communication is just as important. Your attorney should offer a compassionate style, breaking down legal jargon into terms you understand. Additionally, look for absolute transparency regarding fee arrangements, whether they charge hourly or a flat fee. Always check their reputation by reading online reviews and requesting references. Finally, do not settle for the first lawyer you meet. Schedule consultations with several attorneys to find the best fit. Come prepared, take notes, and ask the tough questions. Want to avoid probate? Smart alternatives can save your family time and money. A living trust, for example, allows your assets to pass directly to your beneficiaries, completely bypassing the probate court funnel. With joint ownership, property automatically goes to the surviving owner. Likewise, payable on death bank accounts allow funds to transfer directly to your designated beneficiaries without any court involvement. For smaller estates, simplified small estate procedures might be an option. Since these alternatives require careful strategy, always consult an estate planning attorney to ensure your assets are protected. Navigating probate while grieving can feel incredibly overwhelming, but you don't have to face it alone. A qualified probate attorney provides the crucial guidance and peace of mind you need during this difficult time. For more help, visit probateus.com to find free resources and connect with trusted attorneys in your area. Thank you for watching. If this brought you clarity, please like, subscribe, and leave a comment below.